this is really interesting, Craig. I'm kind of learning a bit myself here. I guess the other thing I wanted to know about today is about the idea of, what happens if I lose capacity or not. I don't die, but I lose capacity in some sense, have an accident or whatever. The idea of enduring attorney, that kind of thing.
Yeah.
Guardianship. Can you go into that a little bit?
Yeah. So when we do an estate plan for someone, we focus on obviously the will, which everyone wants the will part, but
Yeah.
I always stress to clients that it's just as important, if not more important, to do the inter vivos planning. So, like you said, if you're, get dementia, you lose capacity, and people think, oh, this is something just for old people. But I've had plenty of cases where someone's got mountain bike riding, young person, they've come on, whacked their head, and that they need care, and it might only be for temporary, like a short period of time as well. It's just important. I've even got one. My mum's my attorney she was doing helping me do some land property stuff. So I just didn't have time, and so they're handy to have even if you have capacity. Although arguably most lawyers, I'd say, probably don't have capacity, but my dealings with them.
I'm not going to argue with you there.
Yeah. So I guess we always suggest enduring power of attorney. And that's a document that allows someone to make financial or legal decisions on your behalf.
Right.
The enduring part is it endures your incapacity. It's still a valid document after you lose capacity.
Right. Enduring power of guardianship.
Yeah, so that's similar. It's just that deals with healthcare and lifestyle decision making, where you live, who you associate with, and all that kind of thing. I guess the difference between the two is that the power of attorney, which deals with only legal and financial matters, can come into immediate effect while you have capacity, or only on your incapacity. Whereas the power of guardianship one is only on your incapacity, because obviously if you've got capacity, you can say what kind of medical treatments you do or don't want, and you're obviously going to override your enduring guardian appointment. So there's a subtle difference there. There's another subtle difference that you can only have two, some states are called financial attorneys or powers of attorney, active at any point in time.
Right.
Whereas in the power of guardianship, you can have basically as many as you want. And the point of these documents, again, isn't. There may be a way where your kids can get involved or your family can get involved, but it avoids a lot of heartache because you've set up front who you want to do these things.
Yeah.
And if you've got 3 or 4 kids and you think they're all going to sit around arguing about making decisions, you can pick one kid over the other. In fact, this document allows you to appoint a complete stranger if you really wanted to, or a non-family member to have priority decision making in advance of your kids. I mean, there's an overriding kind of supervisory jurisdiction of the State Administrative Tribunal. So if the decision's being made for an incapable person that's completely inappropriate, then there's still a way of kind of making sure that that's checked.
Right.
And if you've got capacity, you can obviously, that's the other question that we get all the time, what if I change my mind? You can revoke it at any point in time. So, and bringing up that SAT situation, if you don't have any of these documents, then your family needs to go off to the State Administrative Tribunal. They need to get a declaration that you don't have capacity anymore, and get doctor's guides and go to a hearing, and it's all a free process through the SAT, but it's very upsetting and it's difficult, and all this could be avoided with just getting it sorted out properly to begin with.
And what about an advanced health directive? Where does that fit into?
So that is where you say in advance what medical treatment you do or do not wish to receive. And not all clients go with that one, but the benefit of that is that if you're in a permanent vegetative state, you're not likely to recover. There's a whole list of conditions that have to be met and signed off by a doctor.
Sure.
But if that's the case, then your guardian or family members thereafter don't have to make the emotional decision about being kept alive only by artificial breeding, artificial feeding, and all that type of stuff. They're not the ones making the decision. You've already made the decision for them. So it's taking the emotional burden off them. And then we have certain religious groups that have particular things that do and don't want to do, and you can specify those things in that document. And there's one other thing that's come up recently, which we haven't had to deal with yet, but it's the voluntary assisted dying legislation.
About that, yeah.
So that's something that's more done through your medical practitioner, and there's some very, very stringent conditions as to, you have to be in a palliative state, or you're going to pass away, and there's no way of recovering, and all it has to be signed off on. That's not something that we prepare, but that suite of documents together is what I consider to be a comprehensive estate plan, and you can put conditions on it, certain limitations. The most common example is when you might even have, for example, husband and wife, an elderly couple living in the house. House is in both their names, and one of them, they need to sell the house to go into residential care or something like that, downsize, and one doesn't have capacity. The husband or the wife that does have capacity can't sign to sell the house because they don't have those documents in place. So that just allows that process, that transition to happen. And a lot of the new retirement home legislation and policies and the leases that you sign when you go into these places require you to have a power of guardianship, power of attorney, and these things set up in advance so that they know who they're dealing with when you start moving into those environments.
So I mean, obviously, all of this ultimately is aiding peace of mind, really, isn't it? I mean, it's that comprehensive approach you talked about.
Yeah. So a lot of the times people may not even use them. They might sit in with their original wills in their safe custody packets. Never need to use them. But then other times, things happen, and even if you need to use it for a short period of time, it's there. It's a cheap insurance policy for a real bunch of problems or inconvenience, really. I mean, the number of times I've had people come to me for very basic, non-contentious applications to the SAT to have their administrator appointed. You've got to get the whole family involved. You've got to go get the doctor's guides and reports, and it just and sadly.
And it's not what people want to be doing in those crises.
Oh, absolutely not. But sadly, what happens sometimes is it's usually the good kid that's been through thick and thin. Their mum or their dad's starting to lose capacity. They might have dementia or something like that. They then go to the SAT to get the process going. The parents don't understand what's going on in those proceedings, and you'll have family members from the East Coast or wherever that, or overseas, that hardly been on the scene, suddenly showing up, and then all of a sudden they're in the ear of the parents saying, "Oh, your daughter's or your son's taking you to the SAT to take away your power, Dad, to take away your decision making," and then it just flips the family dynamic. It's really, really sad. Whereas if that stuff was set up,
so you must see a lot of unsettling kind of realities in that world.
Yeah, it's it blows my mind that people are so adamant that they just want to do their own will kit, and people don't value it. But I mean, there's no skin off my nose. We've got practitioners in my office that are very heavily focused on, estate planning and all that, whereas my kind of love is estate litigation and that kind of complex probate stuff where you're dealing with fixing up issues, and it's a couple of $1,000 or so, now, as opposed to spending thousands and thousands later on fighting about it, or it's just a no-brainer, really.